Welcome to Cowlitz County Superior Court. I am Commissioner Chelsea Baldwin. We are here for the Family Law A docket. So first on the docket, I have Helmets and Bigley. I have Mr. William Ball and I have Brian Hunter. I see you both on my screen.
Yes, good morning, Your Honor. I'm sorry, I'm not seeing my own video, so I'm not sure if you can see me.
All right, I cannot see you, but that's okay. If I have you in voice, that will work for me. And then do I have Mr. Ball? Can you unmute and just let me know that you're present with us?
Commissioner, this is Erica. So William's been having some difficulty getting on. I'm not sure if he's still having problems, but if you want to just come back to our case, I'm going to try figuring out what's going on.
All right, that sounds reasonable. I see him on my screen, but it's not allowing him to unmute or at least connect. I'm going to come back to this case.
Thank you.
All right. Next, I have Kathy V. Dunn. This is cause number 19. Grover, and do I have Cody Dunn? I'm going to have Ms. Height. Thank you. I'm going to come back to this one in just a moment. Right, next, I have Marsden and Marsden. This is cause number 21. I have Mr. Sandy's office and I have Ms. Jeffers. I see you both there. Thank you very much. This is on for a motion to compel.
That's correct, Your Honor. Wife in this case is asking for an order to compel a hard compliance deadline of March 22nd. Our binding settlement conference materials are due on March 29th, so we would ask for stiff penalties if that is not met. And attorney fees as listed in my declaration. The discovery was requested on December 19th. The 26I was on January 26th. We are to receive discovery by February 9th. Nothing has been received at this point. Matter of fact, there was not even a response to this motion. So we would ask that the court grant wife's request. Thank you.
And then Mr. Zandy, I did not see a response. Did you file one?
We did not. This is largely done. It's sitting in my office now. We can forward that. So I think it's largely going to be a moot issue. We did give, I believe, Ms. Jeffers notification of that. It's a case that originally we thought had resolved. So I called off my client from doing this. I would remind you, this is the second request for discovery. It's 45 pages. A lot of it we've already answered in the first round. And second of all, a lot of it is largely irrelevant. They're asking about alcohol consumption dating back to August of 2003. And frankly, there's not even a child at issue on this. So a lot of it's irrelevant. It seems unnecessary. And that would be my response in a written answer. But we have the information. My client has gotten back on this now that we do have the binding settlement conference date. But largely it's moot issues and a lot of unnecessary stuff in 45 pages of a second request.
So when can you have it to Ms. Jeffers?
This afternoon.
All right, very good. So I'll set a deadline of tomorrow. Ms. Jeffers, did you submit a proposed order?
I did not, Your Honor. I was waiting for the court's ruling. So I can do that as far as the deadline as of tomorrow and the attorney fees request.
Did you put a specific dollar figure in your motion? I didn't see one.
I did not, Your Honor. Usually I leave that open depending on the length of the hearing. I mean, at this point, we're about a half an hour in.
All right, very good. What's your hourly rate?
On this case, I want to say $250.
All right. So what I'm going to do is I'm going to award 1.5 hours total to sort of encapsulate drafting the motion, filing it, service, all of that. So I'm going to order an hour and a half at $250. What I'm going to do though, in lieu of you submitting an order, is I'm just going to do a bench order. Says orders or discovery to be provided by tomorrow. And then it's not an official judgment, but you can address that at final orders as part of your binding settlement conference if you want to set it that way.
Thank you, Your Honor. Thank you, counsel.
Rather than the hard copies, if we could just email that to Ms. Jeffers as we normally would do, I don't see a problem with that, and should be there in a couple hours.
All right.
That's fine, Mr. Zandy.
All right, thank you.
I have Ms. Fellows on the line. So with that, let's see. So with that, we are going back to Bruner and Bolt. This is 2230. I have Ms. Bliss, Ms. Jeffers, and I have Ms. Fellows. Ms. Fellows, we're here to review final guardian ad litem hearing and to get an update on where you are in your investigation.
Yes, let's see, I actually am waiting for the substance use evaluation and mental health evaluation of the father. I just received copies of the mother's, so I'm waiting for the father's. So I don't know if he has done them, so I'm not sure about that.
All right. So counsel for father, has he completed the evaluation?
Your Honor, it's my understanding that that was supposed to occur early this month. I don't have the exact date in front of me, but I do recall seeing a card that he had provided from the scheduling, and I wanted to say it was the 7th or so of this month. So I imagine that those are coming down the pipe shortly.
Okay. So that being the case, let's sort of imagine 2 to 3 weeks to get those evaluations in hard copy form. That gets it to the guardian ad litem, let's say 3 weeks. Guardian ad litem needs time to digest that information and turn it around into a report that's quality. So I would probably be looking at mid to late April to set a review as far as having a report done. Does that sound doable for you, Ms. Fellows?
Yes, that was exactly what I was thinking as well. I would suggest having a review hearing on April 25th.
Okay. So that is judicial conference week. And so what I'm going to do is put you out, I'm thinking May 2nd. That puts it out just one more week. Does that work for your calendar, Ms. Bliss?
Yes, Your Honor, that works.
Does that work for your calendar, Ms. Jeffers?
It does, Your Honor.
All right. I think that that's a realistic timeline. I know that's probably longer than anyone wants, but I also know that getting the reports has taken sort of longer and longer, sort of post-COVID. So I want to put you in a place where you're not having multiple reviews where we're kind of in the same position. All right. And then I'm also going to set that onto the afternoon calendar. It looks like there's a disqualification that was filed in the case. So that'll be before Judge Fassett at 1 p.m.
Very good.
Thank you, Your Honor. Thank you, counsel.
Thank you, Your Honor.
Number one on my docket, this is Erica Helmets and Taylor Bigley. This is cause number 18, and I have Mr. Ball present, lovely. And we have Mr. Hunter.
Yes, good morning, Your Honor. I'm here. Again, no video, not sure why.
That's okay. All right. So we're here in part, it looks like a presentation that was sent over from back in February. And so with that, are you agreed as to the presentation?
I think we're agreed on the temporary family law order. I signed that. I didn't receive Mr. Hunter's signature on that. It's kind of last minute, but so I think that one's okay. I think we just have one provision on the temporary parenting plan that we need to talk about.
Okay.
Yeah, that's correct, Your Honor. No objection to the temporary family law order.
Did you submit those orders to the court for signature?
On March 3rd, we sent in the proposed orders. And we sent a bench copy. We submitted the proposed orders under a cover sheet, and we emailed them.
Very good. I have found them. Thank you so much.
Okay.
All right. All right. So you're both agreed as to the temporary family law order. Is that correct?
Yes.
All right.
Yes, Your Honor.
Very good. And Mr. Hunter, Are you agreeable to me entering approved via Zoom on your signature line?
Yes, Your Honor.
All right, very good. I have signed that order. So that next takes us to the parenting plan, with the recognition that I am not the judicial officer who made that decision for you. It's up to you if it's sort of this isn't really something the judge decided either way, and you want to address it with me, or you can set it over 1 or 2 weeks to have Judge Evans address it.
It wasn't something that was specifically ordered by the judge, but I think it's the provision is kind of a right of first refusal. I know maybe the court doesn't have that much of a history about the case, but I don't know how. I'll leave it up to Mr. Hunter if he wants to postpone it. We would like to get the orders entered, however.
Yeah, I would agree. I don't think the judge necessarily made a particular ruling on this. It is a section 14. I'd be happy to just move forward today.
All right, very good. Section 14, can you tell me what page of the parenting plan it's on?
It would be page 8. It's not in there.
Oh, okay.
It's I didn't get included in the proposed order, but Mr. Hunter submitted an objection to petitioner's proposed order.
Okay.
On the 7th.
All right, very good. So,
Yes.
So Mr. Ball, so other than the first right of refusal, you're in agreement to enter this order?
Yeah, I think that's right.
All right, and Mr. Hunter, same for you, or same question to you. Other than the first right of refusal issue, you're in agreement to enter this order?
That would be correct, Your Honor. Yeah, so if the objection we had filed, the right of first refusal was initially inserted. After some back and forth, it was taken out. Other than that one provision, the rest of the parenting plan is not at issue.
All right, very good. And so then that being the case, Mr. Ball, what is your request as to the first right of refusal?
Well, Mr. Hunter did provide the language, the proposed language. We're objecting to it just because it's been a source of conflict between the parties in the past. The court does have an obligation to minimize a child's exposure to harmful parental conflict. Mr. Hunter's objection says that one of the reasons to have this provision is so they can have the eyes on the children or the child when she's with that parent. That provision is already included in the parenting plan. The GAL didn't recommend this provision to be included in the parenting plan, as we've already discussed. It wasn't specifically ordered by the judge. We don't agree to it, but we just feel that it's been a source of conflict between the parents who have, enough conflict as it is. So that's why we aren't agreeing to it at this time.
All right, very good. Thank you much. And then, sir, what is your position? Did we lose Mr. Hunter?
Maybe
Yeah, I just seen that he got disconnected for some reason.
All right.
We're having some internet issues in Vancouver today, so.
It certainly can happen. I'm not seeing him just yet, but I do want to give him a chance to add his comments. So I'm going to come back to this once we have Mr. Hunter rejoined to the Zoom. So I think that leaves us with, I see Mr. Brower still on the line.
Yes, Your Honor. I'm here on the entry of the Dunn Kathy orders.
Very good.
This was put on earlier. We set it over to today to give Mr. Dunn more time to respond. I haven't heard from him on this in response, and I emailed him earlier this week to let him know I was appearing today to enter these.
All right, and do I have Mr. Dunn, Cody Dunn? And I do have Ms. Height. All right, and Ms. Height, did you receive a copy of the orders?
I have not received any orders appointing yet, Your Honor.
Ah. So this was ruled on back in February. What I'm inclined to do then on this matter, because I do think it's important that we get an order for Ms. Height. Oh, and I have one. Oh, fantastic.
Yeah.
Ms. Height, did you have an opportunity? Well, you weren't here at that hearing, correct?
Correct.
That was your. Okay.
No, Your Honor, I just am here right this moment because I saw my name on the docket. That was the first I knew of it. So that's all I've got.
Right. And Mr. Brower, the copies that were sent to me are not signed by you. I assume you are happy to have me write approved via Zoom.
Yes, please. Thank you. And I would be happy to email Ms. Height a copy of the proposed order. And even if Judge or Commissioner, if you want to hold off on entering that one, I can send it to her and give her that opportunity, but enter the other two because they're unconnected in that sense.
Since we have you here, Ms. Height, let's see. This one does not establish a review hearing that I'm seeing.
Yeah, the judge didn't. This is a really narrow guardian ad litem involvement about education across state lines. And so the judge didn't really give us much other than to say appoint a guardian ad litem to investigate what that might be. That's all we really heard. So,
All right, that's fine. All right. So what I've done is I've signed the order inadequate, seeing no objection and not seeing Mr. Dunn here. Hearing was previously set over in court from the 28th. So with that, no changes in child support. The Division of Child Support did put in a notice, but no changes there. I have signed the order on adequate cause, the order appointing the guardian ad litem, as well as the parenting plan.
very good. Thank you.
All right. Very good. Thank you for being here, Ms. Hyde. I appreciate it.
Thank you.
008, Bigley and Heltmans. Someone help me with the last name.
Heltemus?
Heltmus. Thank you.
I'm calling Brian right now on the phone just to see what happened.
All right. Very good. I appreciate that. I know there can be many technical difficulties that happened and he was here. Oh, here we go. He's on my admit list. He just popped up.
Yes, thank you, Your Honor. I apologize. I think whatever was afflicting Mr. Ball got me with vengeance.
I understand. All right. So we were looking at the proposed temporary parenting plan order. Mr. Ball had made the argument just on the limited issue of first right of refusal. Were you able to hear his argument or no?
I believe I heard most of it. I think we got up to the GAL did not make a specific finding. That's kind of the last I'd heard. I'm not sure if there was anything after that.
I don't believe so. The argument was really, the judge didn't rule it either way. Guardian ad litem didn't really address it, and that it has caused a lot of conflict between the parties. And so can you tell me your client's position?
So our client's position is that, one, this was a provision that had been in their final parenting plan that was entered in 2020. We do think it's consistent with the idea of eyes on parenting, but it's also equally applicable to both parties. Yes, the parenting plan creates rights, and with rights comes responsibilities. I'm not aware of anything in the record that shows of any attempted contempt proceedings regarding a right of first refusal. But of course, parents are going to have some dust ups about provisions in a parenting plan, but we think this one makes sense and it's applicable to both parties.
All right. Mr. Ball, any rebuttal?
Well, I had mentioned that there is a provision for the eyes on parenting that's already in the parenting plan, is specifically recommended by the GAL. The reason for the conflict about this right of first refusal is that, there's some pressure on the child as to what the mother's schedule is and where she's going to be. And there has been some conflict over that. Mother had historically had a job where she was a nurse and working overtime or working at nights. And so this is also like an unusual kind of right of first refusal is not really about daycare per se, but it's about like overnights. And so I don't think it's a typical right of first refusal provision that I've seen included in parenting plans. So that's all I have to say about that. Thank you.
Thank you both. Give me just one moment.
Yeah.
All right. I appreciate the concerns on the first right of refusal. Parents want to have as much time as they can with their children. That's reasonable. By the same token, if you make first right of refusal to apply in very short periods of time, it causes a lot of conflict. And so I try to strike a balance with these provisions. So what I've added to the very last line or the very last section, right above section 15, I've just pinned in first right of refusal. If the residential parent is away from the child for overnight or longer, the other parent shall be given the opportunity to care for the child. But then I also add this provision shall not be used to prevent normal childhood events, i.e. camps. So children starting 8 is a little young, but it's getting there. Those are the times where there start sleepaway camps and those types of things. And children shouldn't be prevented from having those normal childhood experiences. So those sort of events are not going to trigger the provision. But if a parent goes on vacation, is away for work, the other parent should have the opportunity to care for the child. All right. Any questions about that?
Oh, not for me, Your Honor.
All right. And then with that, Mr. Hunter, are you agreeable to me writing approved via Zoom for you on this order?
Yes, Your Honor.
Thank you. All right. I have signed that order. All right. Thank you both for your patience and your dedication of getting back onto the Zoom with all the challenges.
Thank you, Your Honor. I appreciate the court's patience. Thank you, Mr. Ball.
Thank you, Judge. Thank you, everyone. Have a nice day.
All right. With that, do I have anyone in my courtroom who believes their case should have been called and has not heard their case called?
My name is Lillian Aldridge, and I think I just missed what happened with my case. Hello?
Yes, thank you. I'm going to see if I can find your case here. There we go. So on that case, I believe we set it over 1 week. Just confirm.
Was it set over for the guardian ad litem or?
Well, it was on for reviewing childcare costs. And Madam Clerk, so this is number 5 on my docket. Can we set that over? It was just one moment to confirm. Oh, your counsel was here, but you were not. So we signed the order on contempt. And sounds like you've reached an agreement on a lot of the other issues. And so just work with your counsel on those other issues to get the paperwork that matches the agreement filed with the court.
Okay.
All right. Very good.
Thank you.
All right. And with that, that completes our docket for March 14th.